Hi, and welcome back to the channel, and thank you for watching. Make sure you hit the like button and subscribe at any point during this video. So we're joined again by Dr. Das, Consultant Forensic Psychiatrist, to talk to us about the experience of giving evidence in court as an expert, as a psychiatrist. Dr. Das, welcome back. You were in court today, I believe, as we did another video earlier, which you can find linked in the description below. Tell us about your experience. What is it like? What is your general approach? And do you feel detached? Whatever you feel to tell us.
Okay. First of all, thank you again for having me on your channel, Mr. Shen-Smith. It's always a pleasure. Yeah, happy to answer that question. So, just to muddy the waters, I actually have a role in an NHS court liaison and diversion team, which is what I was doing earlier on today. So I didn't actually give evidence on the witness stand today, but I have done on many other occasions. I have to say a couple of things. Firstly, I'm going to choose my words carefully because I'm speaking to a barrister here, but one thing that really stands out to me, and something that I was completely blindsided about when I first gave evidence in criminal trials, was the tactics that barristers use to try and trip you up. So I've come to learn that a barrister has far less time to investigate a case, to read through the case papers and the details, than the expert witness who might have been working on this case for weeks. The barrister often gets the bundle the night before. So there's no way feasibly they can know the case, and especially the psychiatric ins and outs, better than the expert. So the way that they win, quote unquote, is to try and attack the credibility of that expert. And there's a number of ways they do that. So, for example, when I was a junior doctor, barristers used to really emphasize the fact that I had very limited experience at that stage of my career. If I spoke to a patient who would not engage, maybe due to their paranoid delusions, the barristers would repeatedly make the point that my assessment is very limited. So they try and find the weakness in the assessment and really try and over-egg it, I think, to fluster the expert or to sow a seed of doubt within the evidence that they're giving. And they also try and draw inferences. So they keep saying, if you said X and Y, then surely you mean Z. And if you mean Z, then, A, B, and C. And it's fine. I think experts can go along to a degree, but when barristers inevitably say something that's not quite correct, or if they're making an inference that's not fully accurate, it's really important to calmly disagree with them politely. And I think that's the thing that some experts find difficult to do. They either just go along and agree with everything the barrister's saying because they're so nervous and they don't really know how to make the argument, or alternatively, they just lose their rag and get really arsey and really defensive and really irritable with the barrister, both of which, in my opinion, are not good tactics. The key is, I've come to learn, is to very, very politely and deferentially go along with them. And then when they've made a point that you disagree with, just say very clearly, no, you're mistaken. And then leave it at that. And then the barrister will have to ask, well, in what way am I mistaken? And then you can start unpicking it and explain what they've said versus what you actually think in your professional opinion.
Yeah, that's absolutely right. And I would say that. I mean, we do, believe it or not, we do specific training on how to examine in-chief and cross-examine experts. And one of the sort of golden rules is don't attack the credibility. So it's interesting that you say that, because one of the golden rules is don't attack credibility unless you're absolutely sure it's going to get you somewhere, because generally speaking, an expert is an expert for a reason. And so attacking the credibility is generally, I would think, a last resort, because the credibility is usually there. It's normally then the credibility of the evidence, and as you say, drawing inferences or inviting others to draw inferences and see the inconsistencies in the evidence and the potential alternative conclusions that one might draw. So for me, the typical line would be, if you as the expert assumed that this was the case, but in fact it was something else, then your conclusion might be different. And as the expert, impartially, you would probably normally agree. And therefore, that is, in my view, is and in the view of the training that I've done, that the best way to approach expert evidence. So I find that to be interesting. And so just very briefly then, bringing it back to the Depp Heard trial, was there anything in either of those expert witnesses in the way that they handled questions that you felt they didn't do very well or could have done better, or the approach to their evidence generally?
Yeah, absolutely. So we talked in our previous video about Dr. Spiegel. He's the one that stands out. So he is a consultant psychiatrist. I think he might have even been a forensic psychiatrist. You'll have to double check that. And he was very defensive. So when anybody questioned that there might be another perspective to what he was saying or another opinion, the correct approach would have been, yes, there are different ways to look at it, but with the evidence that I have, this is the way that I would make my conclusions. Whereas what he did is he almost kind of raised his eyebrows in a sarcastic way and kind of shrugged and basically made this inference that even asking the question in itself was unfair and was not sensible. And I'm pretty sure at one point he even asked, I can't remember what the question was, but one of the lawyers asked him a question and he just kind of shrugged and laughed it off. And then he looked at the judge and he kind of said, do I have to answer this? And then the judge got a little bit irritated with him and said something like, yes, you're expected to answer every question that's asked of you. So I think he tried to get the judge on his side by suggesting that the question was ridiculous, but in fact got kind of chastised in front of everybody. So yeah, that stands out.
Yeah, it's interesting you say, because that's certainly one thing that stood out to me. Whereas on the other hand, Dr. Curry's evidence, in my view, although she was fairly robustly tested, but in my view stood up very well. You don't have to agree with my assessment, but do you the assessment of Dr. Curry, or would you agree with that assessment?
Yeah, I would. I did see a video with her, and I have to admit it was a few weeks ago, and the very fact that I can't remember that much from it, to me, suggests that it must have been quite solid evidence, because I was looking for mistakes that I could exploit and make YouTube videos about, and I couldn't find any. So yeah, I would agree. One thing that I think is quite interesting actually is, you'll have to correct me if I'm wrong, was it Dr. Curry that went for dinner with Johnny Depp's legal team at his house before she was employed and instructed by them?
I think that's the case, yes, and I think there was a lot made about that, but again, I mean, something like that is not exactly out of the ordinary. I mean, if you're going to discuss a case, or whatever it is that you're doing, I think I've talked about this a lot in other videos about professionalism and either actual or perceived bias, and I think it's a very high bar to say that someone, whether an expert or not, is biased in some way. I think that's a very high bar, and so I think that line of questioning didn't really go anywhere at all, in my view. I don't know if you feel the same.
I think I respectfully disagree with some of what you said there, and I'll tell you why. You'll know this, but for your viewers, the expert witness is supposed to be completely neutral. So no matter who pays you, no matter who instructs you, your evidence has to be neutral, objective, and only for the court. It's not supposed to advantage one party. Now, you have to ask the question, what went on at that dinner, and why did the dinner occur? So I've been instructed dozens of, more than that, hundreds of times for cases, and I occasionally, the defense team will reach out for me to ask me whether I have the expertise. So, have you done a murder case before? Have you been to the Old Bailey before? Have you given evidence for not guilty of reason of insanity before? Those are reasonable questions, because they need to know that I've got some experience. Otherwise, they're hiring somebody that's inexperienced and fresh and doesn't know what they're talking about. But respectfully, that conversation, first of all, can be done by a 5-minute phone call, and usually involves me sending a copy. I don't see why it'd be necessary to sit down and have such a long dinner with somebody, unless, and I'm not saying this definitely happened, I'm just saying that it raises the question of a possibility of it happening. Either they were trying to sort of butter up the expert to make her feel loved, comforted, lots of nice free food and drink, or they were trying to coach her, or at least trying to elicit what her views were and what she was going to say and the evidence she was going to give. So again, I just want to make the point, nobody can say, apart from the people that are at that dinner, that definitely happened. But I guess I'm questioning why they needed to have a dinner that was that long, when the conversation, are you experienced enough to give this evidence, is a 5-minute conversation.
No, quite right. And I think a lot of people have raised questions about the judge in the UK trial. Now, I've sort of deliberately not looked into any of that, because I don't want to get drawn into that, I'm certainly not going to accuse a High Court judge of bias, retired or otherwise. So I've deliberately not looked into that. But at the same time, if a lot of thoughts about whether something might look or may give the impression of any kind of bias, then it may have been better to not have done those things or not to be involved. But no, I take your point and I completely agree with it. I don't know the full details of it. I'll have to check that out.
I suppose the analogy that I'd make, if you don't mind me saying this quickly, Daniel, is this. It would make sense for Johnny Depp and his defense team to sit down with a lawyer on their team or a researcher on their team, because they're all fighting on the same side for the same cause. That completely makes sense. But it wouldn't make sense for Johnny Depp's team to sit down with the judge of the case, right? Because the judge is supposed to be completely neutral, objective, and is not supposed to be biased towards one side. So if people found out that they were having dinner with the judge, I think that would send alarm bells and there'd be a lot of criticism. So obviously an expert witness is not the same as a judge, but their position of neutrality is comparable, I think, to a judge. So that might help put in perspective why I think it's a bit dodgy for your viewers.
Absolutely, and I absolutely see your point. Well, Dr. Dast, it's been a pleasure. For those of you viewing, Dr. Dast has some fantastic videos on his channel looking into the minds of criminology, so check him out in the description below. And thank you all for watching. Make sure you like and subscribe as always, and we'll see you next time.
Thank you so much for having me on, Daniel. Hope to see some of your viewers on my channel. Cheers.